The Honorable, Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon. Welcome, counsel, and welcome to all those who are watching on our Supreme Court Live channel. I will ask Mr. Doug Shima, the clerk of the appellate court, to please now read the 1:30 docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Monday, October 25th, 2021 consists of two cases. The first case to be heard on the docket is appeal number 121729, State of Kansas versus Marcus L. Wilson, Sedgwick County, briefs both sides. The second case immediately following will be appeal number 123994 in the matter of Mandee, Rowen, Pingel, matter and attorney discipline. Your Honor, the appellant in State versus Wilson has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court. James Latta of the Appellate Defender's Office, representing Marcus Wilson, ready for argument.
May it please the court. Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Thank you, counsel. Mr. Latta, you may begin your argument.
Thank you. May it please the court. As this court knows, we have a very narrow issue on appeal. The issue is whether out of order intermediate sanctions, a prison sanction before a jail sanction, can be used to revoke a probationer's probation without the utilization of any exceptions. And so given that very narrow issue, there's very limited facts that are relevant. As a brief recitation of those facts, Marcus Wilson pled guilty to a crime and was then placed on probation. He violated his probation, for which he received a 180-day prison sanction first. He then violated his probation again, for which he received a jail sanction. And finally, for the last time, he violated again, for which his probation, was revoked. Based on the petition for review and what the Court of Appeals found, the only issue here is whether the statute was followed properly. And I think where we had some miscommunication with the Court of Appeals is the Court of Appeals interpreted the probation statute 223716C1 as though it only requires a jail sanction and a prison sanction, but that's not quite right. It actually also requires a certain order of events. So it requires a jail sanction prior to a prison sanction, not just either or anyway. And so for that reason, the initial prison sanction is invalid. It doesn't matter that that was never appealed. We simply can't go back and challenge that prison sanction, but it doesn't somehow make it a valid sanction. So given the way things turned out, Mr. Wilson was still entitled to another prison sanction, either 120-day or 180-day sanction, before his probation could be revoked for any reason.
Mr. Latta, is another reading of the Court of Appeals opinion the following. They did find at page 8 that the district court erred in imposing the 180-day sanction at page 8 of the written slip opinion. So it appears to me that they did recognize that there was an order that the statute specified in ordering. And is it possible that what we really are talking about, or they were talking about, is whether that error was harmless?
Yes, I think
they conclude that it was harmless because the spirit, at least, of the statute had been followed.
Yes, I have two responses to that. The first one is, I think this court's Herring opinion from 2020 regarding abuse of discretion for a motion to withdraw a plea, this court should extend it to this instance here, meaning that an abuse of discretion, at least in terms of a legal conclusion, can never be harmless. Some of the analysis in the Herring opinion is relevant, I think, where in Herring they talked about, we don't know how the district court would have applied the lackluster advocacy standard. Well, here we cannot be sure what the district court would have done if it knew it knew it didn't have the discretion to revoke simply because Mr. Wilson had received 2 prior sanctions. Perhaps it would have tried to utilize an exception, or perhaps it would have given another prison sanction. We don't know. And for that reason, I don't see it could be harmless. But as to my second point, Mr. Wilson is still entitled to a prison sanction. It goes back to the statute doesn't just entitle you. I don't think the spirit of the statute just entitles you to jail and a prison sanction. It entitles you to that order. It gets harsher. So probationers know, well, if things are getting worse, we better quit making mistakes. And for that reason also, I don't think it could be harmless. And then really all I have left is we would ask that this court, unless there's any other questions, we just ask that this court finds in our favor, follows the plain language of the statute, reverses the Court of Appeals, reverses the district court, and remands with directions that the district court either impose a 120-day or 180-day prison sanction, or that the district court invoke an appropriate exception.
Counsel, what would your argument be in response to a harmless error analysis that is based on the prior findings of zero tolerance, leading to the conclusion that a remand would lead the district court inevitably to bypass and impose the sentence that was imposed? How would you respond to that as a harmless error argument?
Sure, I would say that since these intermediate sanctions were enacted, the legislature did away with zero tolerance and revoking probation for just any reason at any time. And so, I just don't see how an error of law where Mr. Wilson is still entitled to a valid prison sanction could ever be harmless. We just don't know what the district court would do if it followed the law properly. We can't say for sure they would have invoked another exception just to in effect also invoke the zero tolerance that it did earlier. I say that we still have to, even if I don't think there's no purpose to sending it back to district court just to make them follow the law. Mr. Wilson was entitled to that. And if there's no other questions, I'll just reserve my 3 minutes for rebuttal, please.
Doesn't appear there are any other questions. Thank you. Mr. Gillette?
Thank you, Chief Justice. May it please the court. I concur with my counsel on the other side. This is a fairly narrow issue that we have before us this afternoon. And frankly, based on the questions, I think that this does come down to a question of harmlessness. Three additional facts that I think are worth pointing out to this court. When the defendant initially received the 180-day Department of Corrections quote unquote soak, he received that based on his request. It was a joint recommendation by him and the state after he had received probation as a result of a dispositional departure. That exception obviously is not before this court given Coleman, but nonetheless, I think it is important to understand that the initial complained of error was exactly what the defendant asked for. Similarly, when defendant received his second sanction, he also admitted to a probation violation, and he consented to a jail sanction in that instance. Defendant appealed neither of those findings nor the sanctions that were imposed. And then that brings me to the third fact that I think is also worth this court's consideration today regarding the question of harmlessness. The district court was very clear when it ultimately revoked the defendant's probation. Quote, "We've been down this road before previously," and it acknowledged, to Justice Wall's point, the prior notation of zero tolerance and explained that words have meaning, and it was going to revoke the defendant's probation. The state understands that these two sanctions were applied out of order, but I guess that leaves us with the question of harm. And here, where the defendant agreed to both of the sanctions, he received the only two sanctions that are required by the statute before revoking any probation. And it is clear on the record that this court was going to revoke the defendant's probation based on 3 probation violations within a year after granting him a dispositional departure. There can be no harm. Therefore, as the Court of Appeals concluded under 6261, there was no harm here and reversal is not warranted.
Counsel?
Yes.
So if he had appealed the original prison sanction that did not have a 2-day jail sanction before that, are you saying that this court should have found that there was no harm because the prison took 2 days to pick him up? So that was a de facto 2-day sanction before the prison sanction?
Honestly, I had not thought about that question. I think that would be a potential argument to be made. The invitation to be sent to prison would also be a factor to have been considered in that instance. Because again, he requested this. And frankly, that makes sense given the severity of his crimes and the receipt of a dispositional departure. And then the fact that his first violation was for not only substance abuse, but also the commission of yet another crime. I think that the parties and the record is clear. Everybody wanted to just recommend him restart probation all over again for the most part, following a serious sanction for the serious violations.
So what if they just what if they just revoked his probation altogether in the beginning for a serious crime and just skipped all that altogether?
There would have had to be some more analysis of the potential bypass provisions, and that's something that opposing counsel concedes would still be something to be discussed now.
Why would that be necessary if everybody thinks that it's a serious enough violation? Why do we have to send it back for a judge simply to say that?
I don't think that you do. That my point is that you don't have to. And I know we're trying to go back in time, and if I understand your question correctly, we're talking about harmlessness. Had he appealed the first sanction, and I think that could have been resolved at that time. Had he, we could have addressed other ways that the court could have got there. Whether or not any exist, I don't know. I don't know that that's possible. But the fact remains, he did not only fail to challenge that first sanction, he asked for it.
Mr. Gillette, how do we distinguish Herring, which generally says that an appellate court cannot engage in it's to those specific facts, but in a harmless error analysis when a district court applies the wrong legal standard? And there, of course, it was a plea withdrawal for good cause under 223210. But in this opinion, how would you have us distinguish Herring?
I would distinguish Herring. 2 points. First of all, I don't know that Herring was briefed by the opposing side here, but in regards to Herring, what we're talking about there is a legal standard. We're not talking about a legal standard in this case. We're just talking about a legal procedure, not a standard. The defendant's violations of probation were admitted. The sanctions are provided for by statute. Again, the only question is whether or not they were invoked in the correct order.
But wouldn't you agree that they were invoked in the wrong order?
Yes, we've never contested that.
So it is a legal error, just like the plea withdrawal, right?
No, because the plea withdrawal.
I'm sorry for interrupting. Go ahead.
Sure, no, because the plea withdrawal, we're talking in that instance, we're talking about a legal error in applying the standard of review and how we are to evaluate and consider the facts that are before the district court. That's not the question here. There's no question that the defendant received both of the sanctions to which he was entitled to under the law at most. The only question is whether or not they were applied in the right order. That's not a question of fact. That's a question of law. No one's ever disputed that they were applied out of order. The only question is whether there was harm, and here there isn't. So I think that is a perfectly valid distinction that separates this case from Herring. And
Mr. Gillette, would you agree that given the provision in C1D that says the 180-day sanction can only be used one time, that, what do we do with that since it wasn't technically used correctly? If we were to remand, would that mean that the only avenue left would be the bypass provision? Or in your view, could the judge do a 180-day sanction?
At this point, because the defendant did not challenge the initial 180-day sanction, I don't think that there's any basis upon which this court could order him to get yet another shot at that. The time to have challenged that is long gone. So at this point, I think that we would be faced with probably with a bypass provision, or simply, as you indicated earlier on, I think it's also fair to say that the spirit of the law has been complied with here. He got everything he was entitled to under the law, at most, just out of order. That was at his request.
Isn't it true that the 120-day sanction would still be available?
In my reading of the statute, that is not necessarily correct.
Isn't it true that first you do the 2 or 3 day, then you do the prison sanction of either 120 or 180, and then you can revoke without the bypass?
That is correct. That is the normal order. However, because there was a sanction imposed under C1D, there's no need or basis to go backwards to the 120. At this point, I guess would be my best answer to your question, Justice Wilson. And if there are no further questions, I would ask this court uphold the ruling of the Court of Appeals and the District Court revoking the defendant's probation. Thank you.
Thank you. Mr. Latta, you reserve 3 minutes.
Thank you, Your Honor. I have a few responses. I would just briefly point out that Herring was not briefed because it came out after I filed my petition for review, for which I filed a 609 letter. Moving on, as to any possible invited error about asking for the 180-day prison sanction, this court in Clapp already said that doesn't work. The invited error for that can't be applied later when we're arguing about revocation. As to whether or not the 180-day prison sanction could be utilized again, I actually think it could. I think on remand, they could do the 120-day or 180-day sanction, because the first 180-day sanction is an aberration. It was wrong. If they wanted to challenge that, Mr. Wilson, we should have appealed that at that time. I will point out that I believe that even if we had appealed that 180-day sanction, the Court of Appeals would have dismissed it as moot. They would never have reached it, and they would have said we needed to raise it later on if it was, it was unknown whether it was going to come back to harm, and they would say something like, we don't know if he's going to violate again. And then finally, just to close up, I still don't see how when the law isn't followed as it's written, I just don't see how it can be harmless. I don't see how we can say that the spirit of the law was followed when the law clearly says that we go in order: jail, 120-day prison sanction, or 180-day prison sanction. To say that the spirit of law was followed, we'd just be letting any courts interpret this law as they wanted and go out of order, and the legislature wouldn't be controlling probation revocation if they've tried to with this new statute. And I would urge this court not to find harmless error and to reverse and remand for either the imposition of a prison sanction or for the court to utilize its sound discretion and exception. And if there's no other questions, that's all I've got.
Doesn't appear there is. So thank you to both counsel for your arguments today. We will take this appeal under advisement. At this time, we'll have a short break in the proceeding while the attorneys on this case leave our Zoom conference and while we bring in the attorneys on the next matter. Once they have joined us, Mr. Shima will call the next case. Thank you, counsel.
May it please the court. The second case for the afternoon docket of Monday, October 25th, 2021 is appeal number 123994 in the matter of Mandee, Rowen, Pingel, matter and attorney discipline. The Office of Disciplinary Administrator has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Madam Chief Justice, may it please the court, Crystal Vokins, Deputy Disciplinary Administrator, appears on behalf of the petitioner, Office of the Disciplinary Administrator, ready for argument.
And on behalf of the court, Daniel F. Church, and I am pleased with me, Mandee Pingel, and we are prepared and ready for argument, Your Honor.
Thank you. Ms. Voykins, you may begin your argument.
This is an original proceeding in discipline against the respondent, Mandee Pingel, who was admitted to the practice of law in Kansas in 2007. The respondent was admitted to the practice of law in Missouri in 2005, and this action arises out of Ms. Pingel's self-report to our office that she received notice that the Missouri Office of Chief Disciplinary Counsel planned to institute formal disciplinary proceedings against her Missouri license to practice law, which that office ultimately did. On April 23rd, 2021, our office and the respondent entered into a summary submission agreement pursuant to Supreme Court Rule 223, which is a rule newly enacted in January of this year. In that agreement, the respondent admitted and agreed to the facts underlying her Missouri discipline and to violations of the Kansas Rules of Professional Conduct. And through her counsel, the respondent has cooperated throughout these disciplinary proceedings. In the Missouri disciplinary action, the Missouri office and the respondent entered into a joint partial stipulation of facts and conclusions of law that the respondent was hired to represent the mother in a child custody modification matter in Missouri and was jointly responsible for the representation along with her co-counsel and law partner, Mr. Davis. In that matter, the circuit court judge sanctioned the respondent and her co-counsel jointly in the amount of $100,000. This sanction was upheld on appeal. The sanctions judgment outlined 4 circumstances that the Missouri court found improper conduct by the respondent and her co-counsel. Those were filing a post-trial request for judicial findings that was extremely long and contained incomprehensible statements not related to the case, scheduling the deposition of an expert witness for a Saturday in violation of the court's order, sending a 44-page letter to the opposing party's expert witness in violation of Missouri Supreme Court Rule 56.01 4B, and receiving in excess of $400,000 in attorney's fees in the child custody case. The Missouri panel found and the Missouri Supreme Court held that the respondent violated Missouri Rules of Professional Conduct 4-1.5A, 4-3.4C, 4-3.4D, 4-3.4E, and 4-4.4A. The court ordered suspension of the respondent's Missouri license indefinitely, with suspension stayed while the respondent was placed on probation for 18 months. The respondent has served and successfully completed her 18-month probation in Missouri that ended in April of this year. The respondent filed with this court a supplement to the summary submission agreement when that occurred, attaching an order of the Missouri Supreme Court dated July 9th, 2021, holding that her probation was terminated. In the summary submission agreement with our office, the respondent admitted and agreed that she violated Kansas rules of professional conduct, 1.5A fees, 3.1 meritorious claims and contentions, 4.4A respect for rights of third persons, and 8.4D and G misconduct, which were based on the Kansas equivalent of the Missouri rules found violated. In addition, she agreed that she violated Kansas Supreme Court Rule 221B, which is an attorney's duty to report discipline imposed in another jurisdiction, for her failure to report a prior informal admonition in 2018 from Missouri. The disciplinary administrator's office and respondent agreed to jointly recommend to this court that the respondent's license to practice law in Kansas be suspended for 1 year, and that such suspension be stayed pending respondent's placement on probation for 12 months.
Ms. Vokins, can I jump in here? I kind of understand, of course, we're dealing with this new summary proceeding part. So, we didn't have the benefit of an evidentiary transcript and all that for me to look at, but I can kind of understand the recommendations that you've made for the discipline based on what I would call the lack of, the misconduct and the lack of civility and professionalism that led to the $100,000 sanction, overdoing that litigation. But I need to know more about this $400,000 fee, because to me, that strikes more at the heart of the breach of fiduciary duties, or the ability to exploit the public, or, with a client. And so I'm really I can't reconcile that admission with your recommendation for discipline.
Yeah, and that's understandable, because $400,000 is shocking on its face, and it's just, the respondent agreed it was unreasonable. I think my recommendation is based on several factors. One was the findings of the Missouri panel and Missouri Supreme Court and what discipline was imposed in Missouri. In particular, the Missouri hearing panel report stated that the respondent's motive should be viewed as a mitigating factor, and that was directly regarding the fees. The panel found the overall weight of the evidence compels a finding that there's an absence of selfish or dishonest motives. While she obtained substantial financial benefits in the representation of the client, she intended to provide valuable, zealous, and competent representation to the satisfaction and appreciation of the client. Since it's not in the summary submission record, I don't know how far I can go into it, but I did contact the Missouri OCDC, Office of Chief Disciplinary Counsel, and also Ms. Pingel's Missouri probation supervisor, and learned anecdotally that the client in this case really wanted this level of representation. So based on what investigation I kind of did on that ground, I felt comfortable recommending 1 year probation.
I mean, I think probably all lawyers have had clients that wanted to extract more than a pound of flesh out of the other side and even be willing to pay for it. But part of the professional responsibility that lawyers have is to pull their clients down off the ceiling, if you will, and conduct themselves in an appropriate way. So, so you're telling me that your impression is that this wasn't exploiting the client directly, other than doing what the client sort of wanted and not talking them out of it. I've talked so many clients out of, not going full fully to war, that this still doesn't strike me as acceptable. So
Yes.
I'm really bothered by this $400,000 fee. It's almost unimaginable.
Yes, I agree, Justice Biles. It is unreasonable on its face, and absolutely, she should have talked the client out of spending such a huge amount of money on a child custody case. And that is where it is appropriate that she needs to be disciplined seriously for her conduct. Had I found evidence that the client was vulnerable, or that she misled the client, or that her motives were to obtain money that she did not necessarily earn or spend the time on, I would have recommended a much higher sanction. But based on the Missouri panel's findings, what I learned from the Missouri OCDC office, and considering the success that she had already had up until that point on probation, seemed like her eyes had really been open to the error of her ways and being misled by her mentor and co-counsel, Mr. Davis. I felt that, considering the fact that her Missouri probation would be ending in April of this year, and that any probation in this case would not begin until after that, effectively, if this court imposes the recommended probation, she will have been on probation under 2 supervisors over about 3 years. So considering she had been successful up until that point, I felt comfortable with that recommendation.
Wilkins, I looked at the record to see the plan that was filed in April of 2021, and I noticed that you and Mr. Church had signed it, but I didn't see that Ms. Pingel and Ms. Booth had signed it. Did the probation supervisor, did they actually sign that agreement?
Excuse me, Justice Wilson, the probation and supervision plan? Yes, we had several people in several different places. Mr. Church and I signed the same page, and then there was an additional page attached behind that Ms. Pingel signed on her own, and then an additional page after that Ms. Booth signed on her own.
Okay.
And then,
thank you. I'm sorry, I missed that, and I thought that might be important.
yes, it certainly would be.
Ms. Fokins, I think you maybe touched on it a little bit, but I was wondering what more you can offer us in terms of the relationship between Ms. Pingel and co-counsel, and whether they were both equal players, or whether one was more in a position of authority over Ms. Pingel, or vice versa.
Yes, Justice Wall. I don't want to overstep, because I believe Mr. Church will probably be able to give more detailed information about that relationship. But what information I was able to glean through the documents and through the individuals I spoke with was Mr. Davis had been in practice longer than Ms. Pingel. Ms. Pingel joined Mr. Davis soon in her law practice, in her law career. And it's my impression that he has been her only mentor up until this point. So I believe the relationship was, he was, a mentor at least to her, and maybe that relationship was causing her to make decisions that violated the rules. I see that I'm out of time. I will reserve any remaining remarks for rebuttal.
Okay, thank you, Ms. Wilkins. Mr. Church?
Thank you, Your Honor. May it please the court. I'm going to address some of the questions, I think, in my argument, frankly, of Justice Biles and Justice Wall a moment ago. And then I'm going to let Ms. Pingel speak to you probably most of my time, because I think it's more important for you all to hear from her candidly than it is for me. I will tell you that in 2014 is the year that Ms. Pingel began to represent, and Mr. Davis began to represent Ms. Francis in this very hotly contested child support case. It was a very unfortunate case involving a young child who had some significant mental problems that massively complicated the case. And then you magnified that by some parents who were unruly, and it became a very, very contentious matter. And that led to a lot of the problems. I will tell you that the Ms. Francis and Ed Bozarth, who she's now married to, ultimately submitted letters of recommendation to the OCDC concerning their being extremely pleased with the representation they received from Mr. Davis and Ms. Pingel, and that they had no complaints at all about how much they were charged. In fact, they referenced to the court that they were regularly billed and paid their bills on a regular basis. They got them monthly and would pay them within 15 to 30 days. And so there was not a complaint from the client about the invoice or the amount charged. But I certainly appreciate your question, Justice Biles, because it is a significant sum of money, and there is no question about that. And I think that that if you got into the details of what transpired in this case, you have a bit of an appreciation for why some of it got to the point where it did. However, I think you're going to hear that that doesn't justify not doing what you said, Justice Biles, and that is, you need to make sure that your clients comprehend what it is they're asking you to do and what it costs them.
But it also has an element then of having, your clients having a whole bunch of, not your clients, but being a lawyer whose clients have a whole bunch of resources, and just bringing those resources to kind of do shock and awe and abuse the legal system in order to punish the other side, because that's really what this sounds like.
And I think there was an extremely contentious case, and I think both sides probably, there's a little question. Both sides over litigated this without question, and there was a guardian ad litem, and there were issues associated with that magnified some of the amounts of time and fees and things that occurred. So that made it a little bit more problematic. But I think
Mr. Church, let me ask another question. Who brought the client into the firm? Was it Mr. Davis or Ms. Pingel?
I believe it came in through Mr. Davis, but I'm going to let Mandee respond to that, Justice Biles, because she can make sure to be correct. But I will respond to Justice Wall's comment, because I think this segues into that. Patrick Davis is a much more senior attorney, and Patrick did manage the case. I mean, he has been her mentor, and Patrick makes the decisions. So he was very much involved in this process. And I will tell you, Your Honors, that Ms. Pingel and Mr. Davis have split up since this has happened. She's now practicing on her own, has her own office and her own firm. And I think you'll hear, Justice Biles, that Ms. Pingel has learned an extensive lesson from this particular unfortunate episode in her life, and how it's impacted her and how it's impacted her future practice, which I think is really what's significant here, is that she has learned through this particular matter that there are ways to handle clients, ways to handle clients' funds, ways to handle the expenses associated with litigation that are much more appropriate than what occurred here. And I think Judge Chamberlain recognized that and sanctioned these lawyers for this conduct. He sanctioned them actually $247,000 is what they paid in restitution and sanctions for what occurred. And I believe that is pretty indicative of how he felt about it. And also it was indicative of what they should have paid. And they did pay that as restitution, not only to the parties, but also to some of the charities that he recommended that they pay. So I think that was significant. I think that there's some important things that happened. We had a 2-day hearing in Missouri with the panel. We had a 3-person panel in Missouri that were informed and listened to the evidence, listened to Mr. Davis and Ms. Pingel to talk about where they were, what happened, why what happened, and what they've learned. And I think it was important, and that's why that panel ultimately suggested probation was the appropriate outcome as opposed to some more significant discipline. And the OCDC agreed with the panel's decision, as did the Missouri Supreme Court. And I think that's significant as it relates to the fact that this occurred in Missouri. And I think now that Ms. Booth is on the probation plan in Kansas, Ms. Pingel is doing extremely well in that plan. She's following Ms. Booth's recommendations. She's meeting with her monthly. She's talking about her cases. She's talking about how she handles high conflict cases, what she's doing to address that in a different fashion than what she did before. And with that said, I'm going to sit down and let Ms. Pingel address the court if that's okay, unless someone has any questions.
Got one more. The affidavit that we received on Thursday, is there a reason it came in so late? Because I think the rule required it to be here within 2 weeks.
You are correct, Justice Biles, and I will take the onus for that. That's my error. I apologize to the court for that. I asked Ms. Vokins if the disciplinary administrator's office objected because we didn't get that in 14 days. She said she didn't feel that she did have an objection. She could certainly speak to that momentarily, but it is my error, Justice Biles. I should have got it in 14 days preceding. But I will tell you that the affidavit does address, I think, what's required by the rule in terms of what her compliance with the probation plan.
And I just want to confirm, I had, when it came in, I had my office check, but we had a spelling issue with the attorney registration. Miss Booth is a Kansas lawyer, right?
Yes, she is. Carly Booth. She's been practicing for 20 years, I think. I believe, and I think it was in her plan. It was Walsh before.
Yeah.
Miss Pingel tells me her name used to be Walsh before it became Booth.
Okay.
So I don't know if that's the registration issue or not.
No, I think we didn't give attorney registration the correct spelling.
Oh,
Doing it orally because I was out of town and I just called my office and said, double check that because you doesn't say it. And I just wanted to make sure that we had a Kansas lawyer on.
I think it's Boothe maybe. Yeah.
I think we dropped the E off and then it came back as a no and then we double checked. So
Yeah. I think she's been practicing in Johnson County for quite a while, Your Honor. Thank you very much. Appreciate the court's time. Go ahead.
May it please the court. Good afternoon, Your Honors. I'm standing here today with a humble heart, deep embarrassment and remorse to apologize for my behavior and all of the information that has been shared before you. I take genuine responsibility for my actions, and I deeply understand and appreciate the mistakes that I have made. I want to make it clear that I never had a bad or an ill will motive in what was done in the underlying case. In the moment, the heat of the battle, so to speak, I didn't intend to cross the line with my actions, but obviously I did that. My mindset has always been to follow the law and practice within the parameters of what is ethically and legally required and expected of me. I'm fundamentally, as even a young child, a rule follower. I want to do the right thing. My regret in the case before you is that I allowed my emotional concern for an innocent little 6-year-old boy who had been through so much, including the point of multiple suicide attempts, to make me emotionally attached and, in retrospect, cloud my judgment about my role as an independent advocate. I viewed the stakes in the case as fighting for the life of a little boy, and I analogized it to my little boy who happened to be the same age at the time. I litigated the case as though I would want it litigated for my own child. And when the clients raised things that they wanted done, one example I can give you is there was evidence that the opposing party in the case was altering and editing emails. And so our client became concerned that she was going to be shown emails on the stand that were altered or edited emails. And so we took all of the emails that the parties had exchanged, which turned out to be more than 2,200 of them, and cataloged them in books with tabs and dividers and organizers, so that if she was shown emails in trial, she would be prepared to cross-reference them and determine if she was being shown an altered email or an actual accurate email. And so things along those lines, I wish in retrospect, I would have guided her in a different way. So again, Your Honors, it's not that our office didn't do the work. We didn't pour through the documents. We didn't address the needs that the clients were asking for. It just was admittedly our responsibility to rein in the decisions on the case, and we failed to do that in a variety of ways. I apologize to the Supreme Court, just as I have the Missouri hearing panel and the Missouri Supreme Court, as well as the other lawyers in the case I was involved in, who I personally went to and spoke with, in fact, on more than one occasion, and apologized to. I'm obviously embarrassed for myself. I'm disappointed in myself, for my family, for my children. I've had to talk about this case to my children, and it's a hard thing to explain to your children as an adult when you've made a mistake you're not proud of. I have gone to Judge Chamberlain, the judge that was involved in this case, and spoken with him, really tried to get his guidance and input. Most recently, a few months ago, I had a really extended conversation with him when I separated from my law partner, and he gave me a lot of guidance and support, and really had a lot of suggestions for me about how I can reshape my image to the legal community and recommendations. So I really appreciate his willingness to help me move forward. I take accountability ultimately that in a high conflict situation, I should have worked harder and longer to try to find common ground, bring peace, help be a good role model to the litigants who were already in a high conflict situation. I don't view it as an excuse, but I joined Mr. Davis when I was 18 years old, and he was the only person in the legal community that I really learned from and grew from. And I thought that how he did things was the way to do things. And I've learned and had a lot of realizations and experiences that it's not the right way to do things. In this process, I have, as Mr. Church referenced, I've paid sanctions. There were appeals in the Missouri court from the initial sanctions judgment. It was initially overturned, and then there was a new hearing. So obviously this process has gone on for many, many years. Of all of the expenses that I've paid, even beyond the money, the worst thing to me is all of the time from my life that I've lost, the time I've lost from my children, from their events and activities. And immediately following the court's oral pronouncement of the sanctions, I ended up in the hospital. I missed my daughter's first dance recital that she had at 3 years old. That's something that obviously I'll never get back, but obviously that's part of the personal expense and costs that I have to accept and take on for what this process has been. I understand now that in addition to that, compounding all of that, Ms. Vokins has had to be involved in this process. You all have had to be involved in this process. That isn't the way that I want to use or respect judicial resources. And so I'm apologetic to you all for that as well. What I would like to share though is, in preparing for the Missouri disciplinary hearing, I had to ask several respected and esteemed colleagues to write reference letters. I think those have been submitted to you guys. There's about 15 of them. Ultimately, I was told to narrow them down to that, but I asked many colleagues, and it was a really humbling experience to go to those colleagues and share with them the sanctions and what had gone on and the reason that I was asking for their support. And ultimately, those colleagues not only were they supportive, they've stood by me in a remarkable way, and they have continued to check in with me and support me and cheer me on in a way that's really been a blessing. And I think if I would draw your attention to any of the letters, it would be the one from Michelle Dunn in Missouri. She was my mentor, probation supervisor in Missouri. She's known me for many years, essentially from the start of my career and forward. And I believe that she accurately spoke about how this process humbled me. It changed who I am as a person. It really softened my heart. And she talked about even going through the process and what I am. And as Ms. Vokins indicated, I think she's talked to Ms. Dunn recently and talked about how even beyond the probation, I still turn to Ms. Dunn and use her in that mentor capacity to talk about problems or issues and get her input and advice. Ms. Booth has been a friend for many, many years, since almost the beginning of my career. She similarly wrote a letter of support, and to her credit, she's probably one of the best friends I could imagine, because when I go to her with hard things, she calls me on them. She questions me. She doesn't let me just give her a simple answer. She keeps questioning me. She makes me search things out and come to solutions and answers. She's given me books to read. She has given me suggestions to be involved in various organizations. I joined the Johnson County Inn of Court, and I joined their mentorship program. She is a wonderful mentor and a wonderful, really, supervisor on all of this. She has really taught me more than I could have ever hoped for, even different and beyond what Ms. Dunn has taught me through that process. In summary, I guess what I'd like to say is I've learned so much through not only the probation process, but I've really learned about the kind of person and colleague and lawyer that I want to be towards other people. And I've changed how I interact with and view my colleagues. And when there are difficult or high conflict situations, I now pick up the phone and have those conversations and say, you know, what can we work through? What can we do? I know our clients are high conflict, but we don't need to be. And that was a skill that I feel like I didn't really have back in 2014 and 2015. It's allowed me to radically change some of my relationships for the better with colleagues. During COVID, I knew that everyone was in a difficult and a hurting place. And I started kind of making a challenge for myself that on a weekly basis, I would find a colleague that seemed to be struggling, and I just sent them some charcuterie, and had a friend that was starting a business and I wanted to support her on a regular basis. And so when colleagues would write me and be passive aggressive or rude or disrespectful in some way, I would decide that they were my person of the week. And when I sent some of those things, some of the responses I got back were really kind of life-touching. One person, for example, apologized and said, I had my childhood friend die the day before, and you sending this and acknowledging it in a kind way really changed me and helped me reevaluate the circumstances. So that's been a really awesome opportunity for growth for me. I've also realized the importance of having those mentoring relationships, and that really the early part of my career that they were lacking. So in Missouri with the Platte and Clay County Bar Association, I'm working with the board structureship, and we're creating a women's mentorship lunch that's going to happen on a quarterly basis. And so that's been something that I was really excited about. I want to apologize to the court that the 2018 informal admonition that I received, I did not report. I simply misunderstood my obligations in that regard. That was another case. That was my law partner's case. But because my name was entered into the case, they had to deal with that equally. We understood that we were accepting an informal admonition, and the terms of that letter indicated that it didn't go on any record. It wasn't required to be reported to our insurance or anything else. And so I misunderstood that that was my obligation, but I do apologize for that. In terms of the overall process, what I've told many different people I've talked to is ultimately well, the cost of this whole case has been tremendous for me, not only financially and emotionally and personally and to my children. I wouldn't change it at all because in terms of having gone through now what the discipline has been, I would of course change the actions of the case, but I wouldn't change the fact that I have gone through it to be the better and different person that I am today. I'm a softer, kinder, better person. And I wouldn't want to go back to being the person that I was 7 years ago. I talk to my children about kindness as often as possible. I've had an opportunity to reevaluate a lot of the judgments that I've had towards other people and remove those from my life and realize that that isn't how I want to view people or how I want to interact with people. I look at everyone now and realize that they're fighting some kind of their own battle, whether I know what it is or not. It's not my place to necessarily know. It's my place to try to be supportive and to be kind and share that kindness. I think because I've been open to colleagues about the process that I have gone through and really sought out actively for advice and help and input, I've become a safe space for many colleagues to share their own hurt about substance abuse, mental health difficulties, their personal tragedies, professional struggles, among other things. I understand I have a long-term uphill battle in my career to rebuild my reputation and image. That's something I consider every day of my practicing career. I'm happy to answer any questions that you all may have in terms of the process. I second what Ms. Voken said in terms of the work was all done in the case. I understand and recognize that $400,000 is not a reasonable amount for attorney fees in a case. We were doing what the clients had asked for, and we should have used more effort and intention to talk them out of what was happening. It was a very high conflict case. There were 20+ mental health doctors and people that were involved. The child had suffered a horrific dog maul bite to his face, and he had had plastic surgery. And so there were just a variety of medical issues and witnesses. And obviously with all those medical needs, the parents couldn't agree that the sky was blue and the grass was green. And so there were, evidence and there were things that we had to gather. So the work was all done 100%. It just should have been guided and counseled by myself and my partner in a different way.
What is the percentage of your practice that is in Kansas, and what is the nature of that practice?
Your Honor, I believe that it's approximately equal at this point. I believe I have approximately equal cases in Kansas as I do in Missouri. It's 100% domestic relations related. So.
Thank you.
Are there any other questions? Thank you, Ms. Pingel.
Thank you, Your Honors.
Ms. Voykins, you reserve 3 minutes.
Thank you. I'd first like to confirm what Mr. Church said about the probation affidavit. I did not object to its late filing because at that point, Ms. Pingel has already implemented her probation plan from what I can tell, as I've received 2 quarterly reports from Ms. Booth already, who, before I agreed to her being probation supervisor, I confirmed is a licensed Kansas attorney and appropriate to supervise probation. And Ms. Booth reports that Ms. Pingel is making great progress and is listening and learning. I also neglected to mention a Missouri rule when Justice Biles asked for the reasoning behind our office's recommendation. I wanted to point out Missouri Rule 5.28 on reinstatement. And it's my understanding from reading that rule that in Missouri, an indefinite suspension means that an attorney can reapply or apply for reinstatement after 6 months, unless a specific term of probation is ordered. So, of course, I'm not familiar with these rules as I am the Kansas rules, but it's my impression that after 6 months, an attorney can apply for reinstatement after an indefinite suspension in Missouri. Our office asks that this court accept the parties' stipulations and recommendations in the summary submission agreement.
I need to ask a clarifying question, Ms. Vokins. So the Missouri Supreme Court order, as I'm looking at the submission here, was just about 2 years ago, almost to the day. It was an 18-month plan, so she has completed her probation successfully in Missouri. Is that right?
That's correct. And I believe she submitted an update to this court. That was a new Supreme Court of Missouri order from June or July of this year, affirming that she has completed her probation in Missouri.
Okay.
Any other questions? Anything else, Ms. Vokins?
No, thank you, Madam Chief Justice.
All right. Thank you to both counsel and Ms. Pingel for your statements and arguments. The court will take this appeal or not appeal, I'm sorry, will take this disciplinary matter under advisement. The court is now in recess until